You may be seated. And right here, everything changes. The courtroom goes silent. Because accusing your own lawyer of betrayal is no small thing. Judges take that very seriously, not just because it's disrespectful, but because it can derail the entire case. Question for you: if you don't trust your lawyer, should the court automatically replace them?
Versus Martina Smith. Good afternoon. May it please this honorable court, Kareem Johnson, on behalf of Martina Smith, who's approached to my immediate right. Your name?
Martina Smith.
What are we doing? Your Honor, the defense is requesting an adjournment on this matter. There's been a breakdown in the relationship between me and Ms. Smith. She is seeking to obtain private counsel. Didn't she, other than public defender, didn't she have an attorney before you? No. Okay. Sorry, I didn't really get back to this. Ma'am, what seems to be the problem?
I just don't. I don't feel comfortable.
This is a critical legal moment. The attorney starts explaining Michigan's resisting and obstructing R&O statute. And yes, it's broad. Even talking back or ignoring commands can count. What he's really doing here is damage control, trying to prevent extra charges from piling up. Most defendants don't realize how fast things can escalate.
I don't know what that means.
Well,
Your Honor, she believes that I am working with the prosecution. I've tried to explain to her.
Excuse me? No, go ahead. I want to hear this.
I've explained to her that under Michigan's R&O statute, there are 7 different ways that you can obstruct an officer, including just talking back or ignoring the officer. We've had an agreement for HIDA. I thought we had that agreement worked out. She had me speak to an individual who I believe was her father, indicated that he was a paralegal, and gave me his MDOC number and instructed me to actually hold the exam and let you bind it over. I refuse to do that because I believe the prosecution will be seeking to add an additional at least 4 counts of R&O for the other officers that were there. I told him that what I would do is I would ask for an adjournment because having additional charges added plus walking away from an agreement where she would have no record, her should be in 25, so she needs prosecutors.
Notice the judge's tone shift. This isn't about attitude anymore. It's about courtroom control. When a defendant talks over the judge, credibility drops instantly. Judges see patterns, and this judge is already seeing one. Do you think the defendant is being cautious or sabotaging herself?
For HIDA, I felt it was best for her to get somebody that they feel more comfortable.
Well, so first of all,
you never said nothing about
I know
the charges.
what?
You never said anything about adding charges on her or nothing at all. That's not true.
See, here's what
I didn't.
I'm a bit concerned about, because now you're going to try to overtalk me. Go ahead. No way. You done? Are you done? First of all, yes, because I've watched like for those cases. You don't know how he stands there and not take offense when you're.
This is huge. The judge confirms this is the second attorney with the same complaint. Legally speaking, defendants don't get unlimited do-overs. With lawyers, courts have to balance fairness with efficiency, and right here, that patience is wearing thin.
And he's working with the prosecution for shaking his arm. This man would never do that. Never. I mean, that's what I just find kind of just crazy. I mean, if he really thought it was in your best interest to have the exam, there is not a doubt in my mind he'd hold the exam. So that's the first thing. And I was right. This is now the second attorney. Because it's my staff would be when I looking at paperwork. You had Mr. Elmer, and basically had that same complaint.
Listen carefully. This is the judge laying out the consequences in plain English. Hold the preliminary exam. Risk more charges, accept counsel's advice, possibly walk away. Cleaner. This is a fork in the road moment. Would you gamble and roll the dice here?
You don't get to continue to choose. So I guess part of the problem is going to be set for preliminary examination. And I understand that. Part of the reason the counsel's asking for the adjournment is really to save you. I am almost of the mind that you don't want to take his advice. You don't want to do whatever. Let's hold the exam. If you get charged with that, you get charged with it. It's your call. But I'm not moving from the games. So now what do you want to do? Because we're not going to play this game.
Yeah, may I?
Yes.
Because of the conversation that I've had with her father, I'd humbly ask the court. The court's not going to remove me, to just grant a brief adjournment. Um, I've never asked this court to remove me from a case.
I know.
But we have somebody who has not looked at the body camera footage, advising his daughter on what to do in a criminal case in which she can walk away.
That warning wasn't just stern, it was final. Judges don't bluff about added charges from this point on. Responsibility shifts fully to the defendant. And the irony, the lawyer she doesn't trust may be the only reason things aren't already worse.
With multiple felonies. So I understand the court's frustration. I understand the court wants to move in the docket. But this is not her request. I am asking for, at the very least, an adjournment in this matter. So ultimately, she can have counsel that they feel confident in and make a decision that is not going to negatively affect me.
Well, people have a position regarding counsel. Now get your journey around learning, trusting. So, for this, but on circumstances, I'll grant the adjournment. I can give you. You got to go before then. I'll give you next week or the 13th. I think it is.
What day next week, Your Honor?
The 30th. It'll be Tuesday next week.
That's fine, Your Honor.
The work
Yes, sir.
preliminary examination in this matter will be adjourned December 30th, 2026. 9 a.m. I'm sorry, that's at 12 noon. That's before me.
Yes, sir, Your Honor.
Ma'am, I'm just going to give you a fair warning, and I mean it. I'm not playing this game with you and your team. You gotta listen to them, or you're going to have an exam, and the chips are going to fall where they may. If there are other charges and other things added, there's going to be 2 back for you. And do you think that man sitting next to you isn't trying to save you and put you in the best possible position? Well, that's your fault. No, because apparently with your law degree, right? Bond will continue.
Thank you.
Hit my door. No, she hit my door. Huh? It was soft? No, it wasn't. I heard. What are you trying to say? No, okay. That's fine. I'm not going to make you chase her down. You do the same. Happy holidays. Okay, in the Christmas spirit, let's go. Then that's it. Somebody else do something. That's it. I'm not even looking for your suggestion. It's going to be an order. Pause the case. People versus Nathaniel Bryce.
You guys are not busted in the Mr. Price.
Your name, sir?
Daniel Bryce.
Thank you. It's going to be as complicated as the last case.
Hey, Ron, I expect you wait.
Her expectation is met, Your Honor.
So he's waiving.
He is.
Sir, is that correct? You're waiving the right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
You'll also waive the right.
Do you, Ron, in exchange for these waivers, there will be an offer available to state guilt in count one, attempting assisting or assaulting a police officer, causing injury, with dismissal of counts 2 through 4 and sentencing under 5.
That's your understanding.
That is my understanding.
Defendant is bound over to circuit court on counts 1, 2, 3, and 4 following. Counsel, you acknowledge receipt of the information on waiver.
Yes, I do.
And how does your client plead?
Not guilty.
He pleads not guilty as to all 4 counts. Court will enter that plea pre-trial in this matter. February 12, 2026, 1:30. Judge. You'll continue.
Thank you.
Thank you. Yeah. Happy holidays.
Same to you. Yes, you are. May I approach in a separate matter?
Yes, sir. You are definitely shot. Almost had to chase the defendant now. My son. Court calls the case, People versus James Thompson.
What was the name you're on? Sorry.
Did you think I was calling your client? No.
People. Assistant Public Defender Chelsea deals with and on behalf of James Thompson. Please state your name.
James Thompson. Your Honor. Yes.
The judge made it clear that ignoring legal advice could lead to more charges and harsher consequences.
I would move to dismiss.
For being unable to proceed in this matter, should use the warrant to issue immediately. Thank you. So, good morning. So what's warrant being doing? Down to 9. Oh no! And guess who showed up? How are you, sir? Long time no see.
Yeah, you will.
I'm doing well. All right, then what I'm going to do is we're going to stand in recess for a minute. You guys, the next batch ready to go, we'll do it. Vincent, what are you doing? I don't know. I'm not going to talk to you. I'll talk to him. Getting ready because he's got to get on the sleigh. All right, first thing you should